The last topic for our substantive review of torts is remedies. The National Conference of Bar Examiners doesn't indicate that remedies is on the exam at all, but I'm telling you, remedies issues are omnipresent throughout every bar exam, and remedies can serve as a very practical way to get into a real understanding of how the law works. Remember, a lot of the bar exam, and for that matter, a lot of legal practice, involves civil disputes between litigants in court. The plaintiff will have to have one or more theories of liability and one or more prayers for relief. Understanding how the various theories of liability, not just from torts, but from all of the subjects, relate to the remedies that a plaintiff will seek is very important, because it can help us tie the threads together between the facts in the pattern and practical results in the real world. So, the big picture of remedies is damages, restitution, and equitable relief. And again, as is the case with so many other subjects on bar exams all over the country, the most common mistake people make is leaving things out. So your mental checklist for remedies should include these three broad areas: damages, restitution, and equitable relief. And it's worth keeping clearly in mind the distinctions between damages and restitution, because both with damages and with restitution, the result for a successful plaintiff is the defendant often writes a check and pays money. But there's a big difference between damages and restitution, even if we've got the same number of dollars on the same check from the same parties. And the big difference between damages and restitution is which party we're really looking at. When we're considering damages, we're looking at the plaintiff, and we are concerning ourselves with the injuries suffered by that plaintiff. When we're concerned about restitution, we're looking at the defendant, not the plaintiff. Our focus is on the defendant in restitution because our job is to avoid unjust enrichment. So with damages, we are making the plaintiff whole. In restitution, we are preventing the unjust enrichment of the defendant, and that's a very different mindset. With damages, we're trying to compensate the plaintiff. In restitution, we're trying to prevent the defendant from being unjustly enriched at the plaintiff's expense. And that distinction is very much going to be on our minds as we consider the hypotheticals, both in this subject and in contracts and in property and in the separate remedies seminar that I'm including in this program. You can never work too hard or think too much about remedies. Now, as we consider damages, the broad categories of damages include compensatory damages and punitive damages. And in torts, we need to know quite a bit about both. The big distinction is, for claims of negligence and claims of strict liability, compensatory damages are all that we will afford a successful plaintiff. But where a plaintiff can prove intentional torts, or many of the other torts that we discussed, like, for example, defamation, invasion of privacy, and the business torts, there a successful plaintiff is able to collect punitive damages. So the distinction between compensatory and punitive damages is a key one in torts questions. As we'll see when we get to contracts, we're going to be much more concerned with fine-line distinctions within compensatory damages. But we can wait until contracts to get to that material. For torts, the distinction between punitive and compensatory damages is quite straightforward. Also, you'll see listed on the outline the idea of nominal damages. Nominal damages, in a word, means little damages or de minimis damages. The plaintiff has to show more than nominal damages if the plaintiff wishes to pursue theories of liability arising out of either trespass to chattels or negligent infliction of emotional distress. For all of the other torts, nominal damages are good enough for the plaintiff to be able to establish a theory of liability. We can also consider nominal damages in a different context. First, we consider nominal damages as a very small damage suffered by the plaintiff. But the term nominal damages also can be used to refer to a jury award to a plaintiff, where the jury says, "We agree, Mr. Plaintiff, you've established your theory of liability, but we think it's only worth nominal damages." So that is all we need to know for our purposes in this presentation about damages, as you work through the hypotheticals, you're going to see that I do not neglect remedies. We'll be focusing our attention on how the plaintiff was injured and on how to compensate the plaintiff for those injuries. Next, we consider restitution. And restitution actually is a fairly complicated remedy, and there are a lot of fine print details to restitution that you can really only get through doing a great deal of practice. But for our purposes right here, I direct your attention to one restitutionary remedy called Replevin. And the reason I focus your attention on Replevin for a moment or two is because it looks so much like an equitable remedy, but it isn't. Replevin is where the court orders the defendant to turn over to the plaintiff tangible property that is the object of a dispute. And furthermore, not only is this a legal remedy rather than an equitable remedy, but Replevin is a pretrial remedy, as opposed to many of the other remedies that are awarded only after the plaintiff has successfully established a claim in front of the jury or in front of the judge if it's a bench trial. So Replevin is an interesting remedy, one to be well aware of, and one which is not uncommonly tested on the essays. Ejectment is where we kick somebody off of land. Ejectment is different than an unlawful detainer action against somebody who has overstayed their tenancy. Ejectment is how we eject or get rid of a trespasser. Next, QuasiContract. That's probably the most common restitutionary remedy. And we'll focus on QuasiContract in great depth when we get to contracts. And essentially, QuasiContract is a remedy pursued by a plaintiff who isn't able to establish a valid contract, either because there wasn't a contract at all or because the facts that would be alleged to establish a contract fall short of the legal requirements for establishing a binding agreement. So, rather than pursue a damages remedy for breach of contract, the plaintiff pursues a restitutionary money award to try to avoid the unjust enrichment of the defendant. A constructive trust and equitable lien, these are equitable restitutionary remedies, and again, we'll focus our attention on them in very practical ways through the hypotheticals. I don't have anything further to warn you about them up front, other than remember that the biggest distinction between a constructive trust and an equitable lien is, for a constructive trust, there has to be an ascertainable corpus that the plaintiff has some direct interest in. Whereas with an equitable lien, the court is using its powers of equity to attach property that the plaintiff has no connection with in order to compensate a plaintiff pursuant to the overall scheme of remedies in an individual case. Then, finally, we turn to equitable relief in torts. And for our purposes here, I can point out that the most common mistake folks make is to leave out elements, to do an incomplete analysis of equitable remedies, when in fact what we're basically looking for is connecting the law and the facts, showing a disinterested reader that you appreciate where the law and the facts touch. So, we begin a discussion of equitable relief in torts by explaining how the remedies at law are inadequate. And the most common instance in torts where this is true are disputes involving real property, because all real property is unique. So, as we noted when we were reviewing nuisance is a tort theory of liability, the preferred remedy for which often is equitable relief. So first, the legal remedies have to be inadequate. Otherwise, we'd much prefer to just pay the plaintiff some money and get on with our lives, rather than invoking the more serious equity powers of the court. Next, the plaintiff has to show that some property interest is involved. Modernly, we define property interests very broadly. So, for example, a plaintiff has a property interest in his or her reputation, sufficient to establish a property interest when the plaintiff is pursuing equitable remedies to prevent a defendant from continuing to defame the plaintiff or to continue from portraying the plaintiff in a false light. Next, we turn to feasibility. If the court can't feasibly enforce an equity decree, the court's not going to make it in the first place. In torts, the feasibility of the remedy usually is fairly straightforward. But remember, don't leave it out. It's a detail that's well worth touching on just to make sure that your analysis is complete. Next, we turn to balancing the hardships. Remember, equity cuts both ways, and a court sitting in equity evaluates the case as a whole, and that requires balancing the hardships. Even if we've got a plaintiff who has done nothing wrong and a defendant who is fully liable, even then the court will balance the hardships in order to determine whether or not it is fair to impose an equitable remedy on a liable defendant. So we balance the hardships in all cases. Finally, we consider the defenses that the defendant might offer. And here again, the most common mistake made by people who are writing answers is they fail to talk about defenses both at the level of the theory of liability and during remedies. And with regard to defenses to equity, the most common of these are laches, waiting too long to pursue equity, and unclean hands, where a plaintiff is seeking an equitable remedy when the plaintiff himself or herself has not been acting fairly. And then a final defense to equitable relief that's worth considering is the First Amendment. Anytime we've got a plaintiff who is seeking equitable remedies to prevent a defendant from speaking or from otherwise communicating, the obvious defense will be freedom of speech under the First Amendment. Now, obviously, we do not have the freedom of speech to defame one another, but we do have the freedom of speech to express highly unflattering opinions of one another. And you'll see that the distinction between a mere opinion and a defamatory statement is one that is well worth your attention. You'll see it on the multi-state, and there's a fair chance you'll see it in essay practice as well. So that wraps up a discussion of remedies. Next, we turn to a series of hypotheticals, and I encourage you to make the most out of that exercise. Do not do it passively. Take a look at each hypothetical, and before you watch the corresponding video, try to answer the question. You can either sketch out a quick outline in 3 or 4 or 5 minutes, or you can do a more elaborate outline in 15 or 20 minutes, or you can spend a full hour really trying to get into the question and understanding all of the nuances. For each question, I will follow the same basic approach. I will look at the call of the question, I'll see what we can glean from the question just by looking at the call, and then I'll go through the full fact pattern, and I will help you understand how best to organize your thinking about the issues, and I'll even take a stab at giving you the quote-unquote correct answer. But we'll see plenty of instances in which there's a gray area, and either of two different, maybe opposite opinions could be successful in writing a good answer. So that's it for the substantive law. I hope you found these videos to be helpful. Next, we will turn to the more practical aspect of our work together on torts, the 6 hypotheticals.